Okay, so we have these 8 basic requirements of GDPR, some of them very similar to the Data Protection Act, some of them a bit different. And one of the most important of those is under the GDPR, you do have to identify the lawful basis for processing any kind of personal information. So under the Data Protection Act, this information was part of it, but it wasn't as extensively covered or as important really. So we're going to run through this concept of the lawful basis for processing information. And it's something called the Article 6 clauses, because they're Article 6, but essentially there are 6 legal bases for which you're able to draw upon for handling, storing, managing any form of personal data. Let's just run through what they are first, and then we'll talk about how you can particularly apply these to schools. So basically your 6 legal basis options are, first of all, consent. Consent of the data subject, so they've consented to, and we'll talk about consent in a minute, consented to you holding their data. Secondly, though, performance of a contract. Again, we'll talk about that. But if you have to hold on to data in order to have a contract with that person, then that is a legal reason for having their information. Compliance with a legal obligation, so if you're an organisation that has a legal obligation to perform and data is part of that, that's a good reason. To protect the vital interests of either the data subject themselves or some other person. To perform a task that's carried out in the public interest, or last of all, for the purposes of legitimate interests pursued by the controller, except where that interest is overridden by the interests of the individual themselves. So that bottom one is kind of, I guess, a catch-all for any standard ordinary company, any organisation who, in order to make a go of their business, hold on to various forms of personal data and utilise that personal data. So various things there. However, how does that apply to schools then? Why is this important again? Because under GDPR, every piece of data you hold on a person, you have to have a lawful reason for holding that data. And you as a school will need to make sure that this is formally stated both on your data collection forms and somewhere probably on your website. So if we run through the legal bases then for schools, to be honest, most schools will use the concept of processing is necessary for the performance of a public interest. Pretty obviously, schools are a public interest. Education of the schools, of the pupils is a public interest. And all of the information you hold is in line with that very specific job. So most schools I find are putting public interest in as one of their legal bases. Of course, there's also compliance with a legal obligation. So you have to provide information to the government. You have to put information to the DFE, your local authority, maybe the Charity Commission, who knows, all sorts of bodies require you to provide data. And therefore, if nothing else, you have that as a legal basis for holding data. Some schools are investigating the legal basis of processing is necessary to protect the vital interests of a data subject. And particularly on the grounds of safeguarding, that would seem to be another one that's an option for some of the special information, some of that special category information that you might be holding. Of course, many of you will simply use the legal basis of consent. So as long as you've put together a great document for getting information from parents, and as long as it's very clear what information you're storing, how long, why you're taking it, and it's an opt-in kind of basis, then the consent option may well be one that covers everything that you hold in the way of personal information anyway. And of course, contractual necessity, as it says on the notes here, there's no way of employing staff and paying them and giving them the necessary reviews and payrolls, etc., without you holding their personal data. So certainly anything in terms of teachers or supply staff or peripatetics or anything of that sort may happily come under the heading of contractual necessity. Now, if you remember, there were 6. The last one was this one about a legitimate interest of the data controller, so the company themselves. However, a statement from the Information Commissioner's Office has made it very clear that that's one that as a school you cannot use. You're specifically excluded from that as a legal reason. Doesn't really matter because actually you've got 5 very sound legal bases above for holding information on pupils, parents, teachers and other individuals. And all we need to make sure is that you're clear from the start which one it is that you're using in any given situation. Because you have to specify it when you're mining or grabbing information. So if I return to the privacy notice that we looked at in the previous section, let me just pop it up on the screen. And you'll remember this is a privacy notice that's recommended. It's actually created by the DfE as an appropriate notice for schools. And so if you look on this form, it's telling the parent the information that you're holding on the pupil. Is going on to say why the information is held, and then very importantly here at the bottom of the page it's stating straight off the lawful basis on which we use this information. And as you can see, it's asking you or telling you that this is the point at which you insert the appropriate Article 6 lawful basis option. And then the Article 9 lawful bases are those that apply to the special category of data. So those were the health records, the education records and so on. On the notes that we have popped out to you, there's a link to all of these documents that DfE have provided specifically for schools, and any of the Information Commissioner Office templates, etc., that I look at today are also available on the notes that we pop through. So lawful basis, just being aware that in order to hold any sort of data you have to have a lawful basis for it, and that has to go on your privacy notice and on any documents you send out in order to get information from the parents. Now, one of those, a very important one for schools, is going to be gaining consent. It's for many people the lawful basis that you're going to use as your stated reason for taking information. And consent, we all know what that means. Consent, somebody says it's fine that you're going to store this information, use this information. Remember, of course, that consent must be freely given. It can't be a case of, if you don't give us this detail, your child is not allowed to do so and so. So it has to be a freely given thing. Again, it has to be very specific now. We can't have catch-all consent. We can't have, please sign this form to say that whatever we want we can do with any data we ever mine on you or your pupils. So it does have to be very specific. And again, that little document, the privacy notice document that the DfE have provided and suggest that schools use, this has got everything that we need in here, telling people what you're holding, why you're holding it, how long you're going to hold it for, who you're going to share it with, and so on. So the suggestion is that this information goes with any kind of data collection form so that your parents and pupils know exactly what they're signing up for. Needs to be informed and unambiguous, and very importantly then, specifically with GDPR, is everything must be a positive opt-in now. So you can't have everyone, agrees to this unless you tick the box here. Similarly, there can be no pre-ticked boxes, and there can't be consent inferred from inactivity or from silence. Now, you won't actually have to reissue any of your previous consent or any of your previous forms that you've sent out under the Data Protection Act, unless you look at them and realise now that actually they really do fall short of being clear, specific, properly documented, easily withdrawn, etc. However, because you've all been operating under the Data Protection Act, and it is himself had important requirements for consent, you're probably going to find that's going to be okay. Last thing we'll just talk about in this section on consent is some of the special concerns related to the consent of children themselves.